YSL attorney Doug Weinstein just used Fonnie Willis's words against her as he repulses the attack where the DA is trying to have the judge of the YSL case tell the defense to shut up.
I think that I would welcome an opportunity to sit down with Hank Aaron and discuss that proposed legislation. I don't think that it will be successful. I think if you decide to admit your crimes over a beat, I'm going to use it.
The prosecution then files a motion yesterday to say you can't, meaning you, the whole group of defense attorneys, cannot speak to the media.
This is completely in keeping with the state's efforts throughout this trial to keep the public from seeing what's going on here.
All right, y'all. So if you remember from a recent video of ours from a couple of days ago, we said that DA Love has asked the court to tell the defense to shut up. So DA Love filed a motion asking the court to tell the defense not to speak about the trial in public any further. And we made a video about that. And now we have the follow-up to that from the defense, from the attorney for Diamante Kendrick, Mr. Weinstein. We're going to read this and we're going to analyze it. I think you're going to find it very interesting how Mr. Weinstein responds to DA Love's request that he doesn't speak any further about the trial.
Following this up, the prosecution then files a motion yesterday to say you can't, meaning you, the whole group of defense attorneys, cannot speak to the media when they have tried this case and made speeches, I think, in the courtroom that were really geared towards the media publication of the speeches. Talk to us about that.
Yeah, that's right. And by the way, my apologies. I should have started this interview out with giving a big shout out to ADA Love and ADA Hilton, because apparently they are watching our interviews. But we have not violated any of the rules. Under Rule 3.6, we are allowed to speak publicly about what information that's available to the public. We can get out there. My client is a rap performer. He's an artist. His reputation is being damaged by this trial. We're allowed to go out there and make the accurate assertion that he is innocent of this. So we've done nothing wrong. And I expect that the judge will rule against the state here. And by the way, one last thing, this is completely in keeping with the state's efforts throughout this trial to keep the public from seeing what's going on here. They've repeatedly tried to have witnesses not televised.
This is Kendrick's opposition to state's motion to restrict extrajudicial statements. Comes now defendant Diamante Kendrick in the above styled case in opposition to the state's motion to restrict extrajudicial statements, showing the court the following. We get a quote from Winston Churchill. Everyone is in favor of free speech. Hardly a day passes without its being extolled. But some people's idea of it is that they are free to say what they like. But if someone says anything back, that is an outrage. All right. Now we have words from Fonnie Willis. This is all in the motion. Fonnie says, I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it, which you do that for a form of intimidation and to further the gain and not be held responsible. So those are Fonnie's words in this motion.
The indictment mentions lyrics from a couple of videos.
It does.
And we're going through the lyrics. James Johnson, Congressman, has proposed legislation to limit the use of rap lyrics in prosecutions. Do you have thoughts about that?
I think that I would welcome an opportunity to sit down with Hank Aaron and discuss that proposed legislation. I don't think that it will be successful. I think if you decide to admit your crimes over a beat, I'm going to use it.
And you've used that before with previous gang member arrests. What are your specific responses to the criticism that you're specifically targeting Atlanta's hip-hop community through these lyrics?
I'm not targeting anyone, but however, you do not get to commit crimes in my county and then decide to brag on it, which you do that for a form of intimidation and to further the gang.
Free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of this trial. The state would apparently like the present trial to be conducted in secret, with proceedings happening in hidden chambers outside the prying eyes of the press and public. The state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of the risk to the witness, despite this court's order that such showing be demonstrated prior to blocking the broadcasting of witness testimony. After attacking the integrity of respective counsels for defendants and witnesses, e.g., repeatedly calling the Honorable Brian Steele a liar and accusing the Honorable Jonathan Melnick of working for defendants rather than his client, Kenneth Copeland, the state now turns its attention to counsel for Diamante Kendrick. But to paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them, and they think it's hell. In a 1.5-page motion, the state cites Rule 3.6 of the Georgia Rules of Professional Conduct and cherry picks certain comments to the rule to support its motion to, quote, instruct the defense to refrain from making extrajudicial statements about this case moving forward. This is my note, y'all. In other words, tell the defense to shut up. Back to the motion. No case law is cited. No finely tuned order is proposed. As the state accurately quotes, Rule 3.6 bars lawyers from making extrajudicial statements that a lawyer knows or reasonably should know have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. The state provides no specific quotes of Kendrick's counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by Kendrick's counsel that might arguably violate Rule 3.6. The court should decline this invitation. Remarkably, the state does not make a single argument that any statement by Kendrick's counsel meets any of the elements of Rule 3.6. Instead, the state simply offers up a single conclusory statement. There is no argument that any statement made by Kendrick's counsel was known or should have been known to have a substantial likelihood of materially prejudicing this jury. No argument was made because no argument can be made. The present jury has been impaneled and hearing testimony for months before any statement was made. The jury has been instructed at the conclusion of every day of trial by Chief Judge Glanville through his, quote, ad nauseum admonitions, end quote, not to discuss the case with others or with each other. They have been instructed daily not to consume any media about the present case. No statements made by counsel for defendants can be heard by the jury to prejudice the jury. The state invites this honorable court, which is trying to catch up on hundreds of orders, many of which are provisional, 19 months of trial, over 100 days of testimony, and testimony from almost 100 witnesses to wade through hundreds of minutes of interviews, find statements of Kendrick's counsel that might be objectionable, determine what Kendrick's counsel knew or should have known, and summon a reason about why and how they could materially prejudice a jury that is barred from and admonished on a daily basis from consuming media about the present case. This honorable court should respectfully decline this invitation. In addition, the state conveniently fails to quote from the presumptively safe harbor comments included in Rule 3.6 that permit Kendrick's counsel to speak in public on his behalf. Comment 5BA reads that quote, there are certain subjects which are more likely than not to have no material prejudicial effect on a proceeding. Thus, a lawyer may usually state information contained in a public record, end quote. Each statement made by Kendrick's counsel relates to publicly available information in the public record of the present trial, which is being streamed daily to the public. To the extent there are any remarks not specifically in the public record, such statements are general remarks intended to demonstrate that Kendrick should not be on trial. Justice Kennedy rightfully understood the present situation that Kendrick and his counsel find themselves in. Kennedy wrote that, quote, an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney must take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried, end quote. Justice Kennedy also correctly notes that, quote, the police and prosecution, other government officials, and the community at large hold innumerable avenues for dissemination of information adverse to a criminal defendant. By contrast, a defendant cannot speak without fear of incriminating himself and prejudicing his defense. And most criminal defendants have insufficient means to retain a public relations team apart from defense counsel for the sole purpose of countering prosecution statements, end quote. Justice Kennedy cites the important role that defense counsel plays in educating the public on pending cases, writing, quote, because attorneys participate in the criminal justice system and are trained in its complexities, they hold unique qualifications as a source of information about pending cases. Since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and public rely upon attorneys for information because attorneys are well informed, this may prove the value to the public of speech by members of the bar. If the dangers of their speech arise from its persuasiveness, their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the sort of dangers that can validate restrictions. The First Amendment does not permit suppression of speech because of its power to command assent, end quote. This is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Kendrick is allowed to take reasonable steps to protect his reputation, and those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him, initially by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and injustices around him, and now by holding press conferences denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Wherefore, Kendrick prays the court deny the state's motion. Respectfully submitted, Douglas S. Weinstein. That was a beast of emotion, y'all. That was a beast of emotion. And Mr. Weinstein says he actually toned it down. So you can imagine how hard he was going, maybe in the original version or the first draft. So what do y'all think? I mean, I imagine most people watching this, you made it this far. Thank you. Don't forget to hit the like button. But I imagine most people watching this say, look, let them talk, let them speak, let them have free speech. And I would imagine a minority of people, probably 1 out of 100, would say, no, you should keep it all close to the vest, keep it quiet until after the trial. But should the judge order them that they can't speak is the question. So let me know, y'all. Write your comments down below and let me know what you think.